Steve, are you introducing our speaker?
Yes.
Okay, over to you.
Several years ago at UCLA, and we kicked off Assange defense here in California. I met Kerry. We've become colleagues and friends. He has done an extraordinary job throughout these years. He testified at the Assange extradition hearing through his written statements, I believe, and has finally completed a masterpiece on the history of the Espionage Act. I didn't alert you, Kerry, before, but we love speakers to weave into their remarks your personal journey to this work, what has brought you here from all the threads of your life. And I'm going to leave maximum time for you to make your presentation. Thank you, Kerry. I also promised my board, and maybe you want to do this now, Rose, we depend on the generosity of our friends and supporters. And when you got your announcement for today, there's a green box of ways that you can contribute to ICUJP. We have a very small part-time paid staff and are largely volunteers, but we have all the expenses involved in presenting our programs, our meetings, closed Guantanamo, and other events throughout the year. So I know it's difficult to feel the connection to us online as we used to do in person, but please take a moment, be as generous as you can in supporting us financially. So thank you so much, and I will turn it over to Kerry.
Thank you so much, Steve, for the glowing introduction. I really hope that I can live up to it. And thank you for everyone on this call for your work, for your contributions and commitments to such important issues, and also for coming out this Friday morning. I'm really touched to see the interest and the engagement with these issues, which I think without hyperbole are among the most important issues of our time. And I hope that this conversation isn't limited to this group and this time that we have together now, but that these are things that we can all continue to engage in. I did want to actually take a moment and again commend and call out. I don't want to put him on the spot, but to commend and point out that Thomas Drake is on this call, and if he's willing, I'd absolutely love after this presentation. I would actually be more interested in hearing from him than hearing myself speak. But I think that's really a treat for folks on this call if you're not familiar with his work, and also the sacrifices that he has made. I talk about Thomas Drake and his career and what happened to him in his Espionage Act case. Also, there's a thread of the Computer Fraud and Abuse Act, which I do go into in the book. And I think folks don't talk about the Computer Fraud and Abuse Act enough, but it is a key component of the prosecution against Julian Assange. So after my presentation, I'd be absolutely thrilled to hear more from Tom. Good. Yeah, and I support making this as interactive as possible. If folks want to raise their hand in the middle, I'll just try to make sure that I see it in the Zoom. Sometimes it can be hard when the slideshow is going on, but I don't love hearing myself talk. If I had it my way, I would end my presentation right now and open it for questions, but I'll jump right into it. So to give a little bit of background before I get into the slideshow, actually, maybe I can share my screen and have that up. So my name is Kerry Schenkman. I'm a human rights and civil rights lawyer. I've been in practice for close to a decade now. And I actually started off my legal career working with Espionage Act issues. So when I was still in law school, I attended the court martial for Chelsea Manning. I was at NYU at the time and got introduced to folks at the Center for Constitutional Rights, as well as Michael Ratner. who, and as well as Jen Robinson, who were core members of Julian Assange's legal team. And through seeing what was happening to Chelsea Manning firsthand and beginning to follow these cases, it really drew me in to what I viewed as the most serious threat to freedom of expression in our time. At the time, I had been interested in First Amendment issues. So I had, before law school, and when I was in college, I had been a radio journalist for several years, and I was always interested in journalism and media rights. And I saw locally in New York City at the time. So when I moved to New York was when the Occupy protests were happening. And we had a human rights clinic that was working with the National Lawyers Guild at the time to look at how the NYPD and also the federal agencies that were involved were responding to journalists, the press, and independent media like bloggers and other live streamers who were trying to cover the Occupy protests and show what was happening to the world. And what we saw was really astonishing, that it wasn't haphazard. It was a really coordinated effort to suppress the media reporting on Occupy. And I think it was that experience coupled with seeing the Manning court-martial firsthand that really pressed the urgency of looking at the ways that the First Amendment, if we don't protect it, if we don't fight for it, is simply words on a page, but that there are forces within our successive administrations that would see those rights just be words on a page. So that's what really has drawn me to the work around the Espionage Act. I ended up working with Michael Ratner for several years after that, until unfortunately his passing in 2016. For folks that don't know, Michael was a longtime defender and a longtime defender of civil liberties. He was the first attorney to really stand up for cases surrounding Guantanamo. His work with CCR went back decades. He's truly a radical lawyer at heart. And even when folks were not standing up in defense of Julian Assange, he was one of a handful of lawyers who really saw, I think, had so much foresight in terms of where this case would go, even when folks would say when Julian Assange was in the Ecuadorian embassy, and this was maybe 2010, 2011, there wasn't any public indictment or anything of the sort. And Michael said even back then that they're gonna basically want to nail him to a cross. And his whole political experience, his whole legal experience had informed that, where I think he knew off the bat what was going to happen in that case, which we've seen to be the case so far. So my journey has brought me here. After Michael passed, I went into private practice, where I focused on a number of issues, from digital rights to freedom of speech, both domestic and international, and of course working on this book. So happy to answer more questions about my own work, but that, in terms of kind of the personal journey that brought me to these issues, is where I'm at. I think now, after the release of this book, I sometimes joke with folks that I'm Espionage Acted out, just because this project was really a labor over 8 years, but not a labor as in work, really a labor of love, not for the act. It's probably a labor of resentment if it's about the act, but really a labor of love of the human side of the folks who've had to make sacrifices, honestly, like Thomas Drake, who's on this call. And I think something that we really wanted to highlight was the human and personal cost and impact that these cases can have, that I think often can get lost when we're talking about these very high level abstract issues. I think it really is important to keep front and center that there are human beings that are impacted by these cases, by these trials, by these laws. And I do also want to call out to Daniel Ellsberg. I'm so glad that you noted him before. For folks that don't know, it was actually he just announced that he was diagnosed tragically with terminal cancer and may have 3 to 6 months to live. Daniel Ellsberg has been one of the fiercest defenders of our First Amendment liberties for decades. And even now, with his diagnosis, he's still been so forceful in the defense of the principles in Assange's case. He's been very, very vocal in issues surrounding nuclear non-proliferation. And he's also been a great mentor and supporter of us through this book project. So I'm just so grateful to him. And I hope for folks on this call too, that we can be grateful to him, to Tom, and to all the folks that have done so much to stand up for our personal liberties. So I'll turn to the Espionage Act and its relationship with freedom of the press for this presentation. And I'll try to keep it to 40 minutes because I really am curious what you have to say on your end. And I'm eager to answer questions. Also, if we don't have time here, I'm pretty responsive over email, or if you want to chat over the Zoom. So starting off with the Espionage Act of 1917, why do we care about this law that's over 100 years old? Why is this law that's over 100 years old being used in the Assange case and all these cases? Here's my book. The reason that the Espionage Act is making front page headlines today, over a century after it's passed, is because it is the main law that is used to go after US government whistleblowers who are exposing truth to power. And depending what happens in the Assange case, if he's extradited to the US from the United Kingdom, it may well be the primary law used to prosecute journalists. That said, it's not an exaggeration to say that the Espionage Act of 1917 may be the single greatest threat to investigative journalism in America today. It's caused numerous civil rights organizations to point out the hypocrisy of the Biden administration. So the indictment in the Assange case was passed on by the Obama administration, but revived under the Trump administration. And to this day, the Biden administration has refused to reverse course on what Trump started. There's a great article that actually just came out in Harper's that I encourage folks to read, but it talks about the interaction between Julian Assange and the media. And one of the issues that's faced is reluctance by many outlets to talk more about this case and its implications, which I find astonishing because it's a case that could threaten the livelihood of those very media outlets. And I think more outlets have come and spoken out. So the New York Times has come out in opposition to the extradition and the case, but we still see quite a bit of ambivalence. And this is a result of trends that we've seen going back 100 years. So what's at stake with these cases? I've already mentioned the threat to news gathering itself, but there's also more at stake, such as the constitutional balance of power. When we talk about these cases, about the relationship to secrecy and allowing a law like the Espionage Act to remain on the books or not even be amended, we're basically handing a blank check to the executive branch regarding secrecy. We're abdicating that balance of power that should be balanced between the courts and the legislature. We're also endorsing novel methods to whitewash press freedom violations. One of the reasons, as I just pointed out, that media outlets often don't support Assange or have ambivalence is because he's been painted as a hacker. He's been painted somehow as a spy, even though the indictment against him has nothing to do with anything that's alleged past 2013. The indictment alleges that he's a hacker, but this is also a type of smear that we've seen across many cases. The law that's used against Julian Assange, in part the Computer Fraud and Abuse Act, sounds scary. Sounds like, oh, that's a computer crimes law. In fact, that law was implicated, and maybe this is something that Tom can talk about. That's something that came up in Tom's case. That's something that came up, of course, in Chelsea Manning's case. And what I suspect we're going to see, it's something I actually want to write more about, is the trend of casting folks as hackers, of exploiting a lack of understanding of what that word even means to try to paint folks as criminals. So I'll touch a little bit on that as well. But taking a step back, and my presentation, it's going to be about the Espionage Act generally, but I think we need to address the elephant in the room that this act is at the center of the Assange case. But for context, Julian Assange is currently being charged with 17 counts of violating the Espionage Act of 1917, arising from his role in publishing extensive human rights violations and war crimes regarding Iraq, Afghanistan, and around the world. Note that says human rights violations surrounding Iraq, Afghanistan, and I don't say explicitly, but regarding the State Department cables. It does not talk about the 2016 election. It doesn't talk about Russiagate. It's because he's not being indicted with anything surrounding that. In fact, there have been no peeps or mentions of any shred of criminal liability or prosecution surrounding that. But it has to do with the 2010 blockbuster award, journalism award-winning publications that WikiLeaks led. In addition to those 17 counts under the Espionage Act, there's one count under the Computer Fraud and Abuse Act. Julian Assange is not being accused of espionage, as you or I might understand it, being a spy who's clandestinely paid by a foreign power to deliver secrets. That is not what Julian Assange is being accused of. So as we move on, I want you to keep two things in mind that I am surprised that folks don't talk about more, because when we really frame this case in these two questions, it becomes so clear how absurd the US government's position is in the Assange case. So the first question is, what would we think if this happened elsewhere? You take the same set of facts. So right now you have the war in Ukraine. What if an individual in the US exposed the trove of documents revealing war crimes committed by Russia in Ukraine that showed innocent civilians being killed? And then Russia wanted the US to extradite that person. Say that person wasn't even a Russian citizen, had no connection to Russia. What would we say about that case? What do you think the US press, the US government would be saying about that case? Similarly, if you had someone in the US who, or rather you had someone in the US who was a Chinese citizen that exposed evidence of surveillance in China. And then they were criminally charged by the Chinese government, which then sought their extradition to China. What do you think we would be saying about that case? Question number 2. Is Assange a whistleblower? No. Julian Assange is not a whistleblower. He is not. You hear this all the time. Julian Assange is like Daniel Ellsberg. Julian Assange is like Chelsea Manning, is like Thomas Drake. No, and Ellsberg says all the time, no, this distinction is not a legal similarity. Because Julian Assange did not work for the US government. Assange never agreed to keep secrets. He's not even a US citizen. So to say that Assange is somehow a whistleblower or liken him to the legal position of an insider, and just to be clear, I also don't support or advocate for the prosecution of insiders. The application of the Espionage Act to US government insiders is greatly abused and misguided. But taking this law and applying it to someone who's not even a US government employee, not even a US citizen, just goes even further than that. So when we say that Assange is not being accused of espionage, why are we using a law called the Espionage Act? Why is it even called the Espionage Act? What's in a name? And the Espionage Act actually goes well beyond espionage. It's the key law that's used to prosecute government whistleblowers who are not being accused of working for a foreign government. It can apply to government employees, members of the general public, as we see now, even non-US citizens. That's the US government's position in the Assange case. It could literally apply to anyone on earth. It broadly punishes the receipt, retention, and communication of what's called national defense information. Then you might hear, well, okay, punishes the receipt and communication of national defense information. Well, that must be important stuff. That sounds pretty scary, right? National defense information. But that does not mean military secrets, codes, troop locations, closely guarded information. It does not need to be classified. And it can include evidence of torture, war crimes, corruption, government criminality, waste, fraud, or abuse. In fact, the US position is that all of those things like the collateral murder video showing the slaughter of civilians, things like exposure of corruption and widespread waste, somehow are national defense information. So in approaching this law, we in writing this book, we really wanted to dive into the political roots of the Espionage Act and figure out, is there a context in the 100 years of this law that informs how it's being used today? So we dived into the Woodrow Wilson administration and started there. Our book actually goes through we divide it into 3 periods. So the first are the 2 world wars. The second is the Cold War, and the third is the so-called War on Terror. And we see how the Espionage Act actually plays this really key role behind the scenes in all of these conflicts, actually, that this act has been a key component in serving as a threat to freedom of expression behind the scenes. So originally, the act was passed during both one of the most politically vibrant, but also politically repressive periods in modern US history. So during the US entry into World War I, actually, which was a dramatic shift in the US position, the US was isolating itself from what it viewed as a European problem up until Woodrow Wilson changed course and decided to support U.S. entry into the war effort. But just a couple months after that entry, the Espionage Act was passed because it was seen as a tool to fight against the Germans at the time. It was basically an anti-sedition and anti-war law, if you will. But the speech that Wilson gave supporting U.S. entry into the war, and we quote extensively from it at the beginning of the book, and really paint a scene of Wilson's address, which in many respects was quite dystopian. But he talks about how disloyalty must be stamped out with, quote, a firm hand of stern repression, afterwards calling for legislation to be passed to stamp out that disloyalty. And the Espionage Act was a key part of that legislation, which also included a Sedition Act, the first Sedition Act that the U.S. had seen since the Alien and Sedition Acts, which we all learned about in U.S. history. So the Espionage Act, as it was called, punished conduct well beyond espionage. Again, we go into a lot of the details of that, but I did want to read one passage that I think was really emblematic from Title I, Section 3, which is a seditious libel provision. And that essentially addressed expression of anti-war and anti-draft sentiment. So that provision from the original Espionage Act punished whoever, when the United States is at war, shall willfully make or convey false reports or false statements with intent to interfere with the operation or success of the military or naval forces of the United States, or to promote the success of its enemies, and whoever shall willfully cause or attempt to cause insubordination, disloyalty, mutiny, or refusal of duty in the military or naval forces of the United States shall be punished by a fine of not more than $10,000 or imprisonment for not more than 20 years, or both. And if you're hearing that, and if you're thinking, well, that sounds like it could punish conscientious objectors, that sounds like it could be used to punish folks who are against World War I, you're absolutely right. Those were the first prosecutions under the Espionage Act. In fact, those were the cases that launched Roger Baldwin, the ACLU founder's career. Those are, in fact, the cornerstone of the modern ACLU, were these cases defending folks against the Espionage Act. And in fact, the first major U.S. Supreme Court cases on the First Amendment were Espionage Act cases. These provisions literally shaped and defined the First Amendment, which up to that time was a clause in the Constitution, but hadn't really been tested, apart from some debates about whether prior restraint was or could be allowed. Prior restraint is the government blocking a person or publisher from publication. That was the core issue actually in the Pentagon Papers Supreme Court case. But apart from that, the First Amendment wasn't really a thing that people were bringing to court until World War I. So I mentioned that this was one of the most politically vibrant periods in U.S. history. And at the time, the Socialist Party was at its peak. The labor unions were one of the strongest forces in the U.S., with the industrial workers of the world, the Wobblies, and the Socialist Party led by Eugene Debs, who was imprisoned actually under the Espionage Act for his famous Canton, Ohio speech, which was considered one of the greatest protest speeches in history. So this act was really used to several thousand prosecutions to go after the left, to go after the anti-war movement, and to go after those who were speaking truth to the war. It wasn't used to go after spies. That wasn't the main impact of the law. So when we saw this, we really we really saw the connections between how that law is being used today in response to exposing war crimes, exposing misconduct, and really stuff that the US government would prefer the public not to know. And there's this common thread when we look at the whole history of the Espionage Act. And I wish I could go through and tell all these different stories, because so many of them are astonishing. There's ones that are bizarre. We thought about maybe making a thriller out of some of the, I mean, some of it is really interesting stuff, and that doesn't really get talked about too much. But what I do want to focus on is how some of these provisions that I mentioned, so the seditious libel provision that I just read, that part was repealed. There are aspects of the law that have been repealed, but some of the most important parts of the Espionage Act that are in play today have roots back to 1917 and were upheld when the act was amended in 1950 at the peak of McCarthyism. So the part that I want to draw attention to that is one of the key Espionage Act sections is Section 793E. And that punishes whoever having unauthorized possession of any document relating to the national defense willfully communicates the same to any person not entitled to receive it shall be fined under this title or imprisoned not more than 10 years or both. So you might look at this and think, well, that sounds pretty darn broad. Whoever having unauthorized possession communicates it to anyone not entitled to receive it. It's pretty broad, right? And high-profile constitutional law professors would absolutely agree. And I will add, these are professors across the political spectrum. The Espionage Act, the use of the Espionage Act is bipartisan. It's been used by Democrat and Republican administrations. Woodrow Wilson was a Democrat. Barack Obama, who prosecuted more media sources within the US government under the act than all presidents combined, was a Democrat, of course. And it's the same with law professors who have spoken against this act across the political spectrum. So there's Stephen Vladeck, who's a regular commentator, I believe, on maybe on CNN now, but he's called the act anachronistic, labyrinthine, and constitutionally problematic. In the most seminal review from the 70s, on the heels of the Daniel Ellsberg case, Columbia law professors Harold Edgar and Benno Schmidt Jr. said that due to the Espionage Act, public speech in this country since World War II has been rife with criminality. You've had several high-profile folks speaking out against the Espionage Act, including a law professor, Jeffrey Stone, who called for its repeal and replacement. And most, I think, relevant here is that former Attorney General Eric Holder Jr., Obama's Attorney General, and former CIA Director John Brennan wrote last year that the Espionage Act should be amended to make clear that the press cannot be prosecuted for core journalistic activity. Which is really remarkable, right? Because Eric Holder had overseen that record-breaking number of Espionage Act prosecutions. In addition to that, was pushing this line of calling members of the press potential co-conspirators and also spying on and searching journalists, which was revealed through court records. So to then hear some years later that he's in favor of amending the act with some caveats and footnotes and fine print, but just even coming forward, I think is really remarkable and shows just how bad this law is. So we can kind of look through the book for more pictures and context, but here's some snippets from the movements of World War I and some of the protests and anti-war sentiments. There's Eugene Debs for his Canton, Ohio speech. I'll skip over these ones. When we're talking about the history of the Espionage Act and its use against folks like Eugene Debs and the anti-war movement, those cases didn't involve a publisher who was publishing US government secrets. And that's where the Assange case is remarkable and unique. Because the Espionage Act has been used countless times as a tool for political repression, and up until its amendments that remove some of those seditious, libel, and conscientious objector provisions, the law hadn't been used to go after publishers for publishing secrets. And that was a line that several administrations came close to. So there had been an attempt to prosecute the Chicago Tribune during World War II for publications surrounding the US victory at the Battle of Midway. There's a grand jury convened to investigate a journalist and his editor, but that case ultimately fell apart. There are also other attempts to investigate or potentially prosecute media outlets for secrets. The other big uptick was under the Nixon administration. We saw several attempts surrounding the Pentagon Papers case. So many folks may not know that, because it doesn't get talked about as much, but there's actually a separate grand jury during the Pentagon Papers case that was convened in Boston that was investigating academics like Noam Chomsky, Sam Popkin, and numerous others who were involved in the anti-war movement during Vietnam, as well as seriously considering whether to prosecute the New York Times and other outlets. So there are FBI agents that were sent to Beacon Press, which was the small religious press that had published the version of the Pentagon Papers provided by Alaskan Senator Mike Gravel. These are all threads that we dive into that actually the stuff that we dug into, and I had made a bunch of trips to the National Archives and gone through like thousands of pages from the original Ellsberg trial and cases to where Dan actually said that he learned a bunch about his case from a lot of the original research that we did. And so there had been upticks like during the Nixon administration, but that line hadn't been crossed. And I think that's what I want to emphasize, is that the line that's being crossed in the Assange case has never been crossed before. Even Nixon didn't cross it. Came close, very, very close, but a publisher had not been prosecuted for the publication of secrets. So I actually forgot that I had slides for some of these things, so I apologize for stopping on that somewhat boring slide. But the Chicago Tribune story about Midway. So this is the headline from the Tribune. So again, we talk about this case, but basically it was a really bizarre case, because the Tribune this wasn't a look at the US, look at all these bad things the US is doing. It was saying, hey, look, we won at this big battle. The fleet was smashed, and the story in question is in the center on the second line. Navy had word of Jap plan to strike at sea. And here the Tribune was basically bragging about the scoop, but it turned out that a story spilled that the US had access to the Japanese naval code. And at the time, and it came out later, that this actually didn't put the Navy at risk. There was minimal impact from it. But what came out, and we felt super relevant for today, was that the Tribune was a huge political enemy of FDR. And it actually came out through the research that we did that this was a big consideration for FDR's motivation, the DOJ's motivation to go after the Tribune, because Roosevelt was looking for a reason to go after McCormick, who was the publisher of the Tribune. He was one of his number one political enemies, was constantly giving negative coverage to FDR and the New Deal. And this is a thread that we see, that these cases are subject to so much political pressure. It's really unreal. So that's the editor and the reporter, Maloney on the left, and Stanley Johnston. There's a whole book actually on Stanley Johnston that came out a couple of years ago. That's a good look into that whole case. Of course, folks know about the Pentagon Papers case that there's other time I mentioned Nixon came close. And of course, Dan was acquitted. I will say of important note also is a huge parallel to today. The reason that that the case against Ellsberg was dropped was not because a court held that the Espionage Act was constitutional, or that that Ellsberg had not violated the Espionage Act. In fact, he maintains that he would have been sent to prison for life. Like that was what his lawyers, everyone watching this case and the direction that the rulings were headed, that he was done. Like there's no way that he was going to be he's going to be acquitted. What happened is Nixon's plumbers started spying on Ellsberg's lawyers and wiretapping his calls with lawyers. They broke into a psychiatrist's office to try to dig up dirt on him. And they also offered the judge in the case a position at the FBI. And when all this came out, it was just got so dirty. There's so much misconduct that they had no choice but to throw the case out. It just became so tainted and so untenable. And you might draw some parallels actually to some of the things that we've been seeing in the Assange case. And I think some of the same conversations are happening about the plot to assassinate Assange, the surveillance of his lawyers, of journalists visiting him. And these aren't tinfoil conspiracy theories. These are high-level pieces that were well-sourced and confirmed by multiple sources. Aspects of this Mike Pompeo bragged about himself in his new book that came out weeks ago. So we really see these parallels of these kind of impunity in these cases. But still, we hadn't seen that line be crossed with a publisher. We have seen over the last decade a huge uptick in the use of the Espionage Act to go after US government sources who are not exposing things for personal gain, who are doing it in the public interest to bring either huge policy missteps or exposure of human rights violations, corruption, or waste, fraud, and abuse. Many of the folks on the slide, and we talk about their cases in depth that you'll recognize. I want to also reiterate Thomas Drake in the lower left corner is on this call right now, and I hope that we can hear from him in just a little bit. And so it's mentioned Obama had prosecuted more journalist sources than all administrations prior to that. Journalists had increasingly been implicated. I'm going to zoom through this a little bit, so don't worry if you missed some of it. I could also make the slides available if folks want those. What I do want to mention, because this comes up a lot, like why don't folks just face trial? You heard it. You heard Obama say this about Edward Snowden all the time. Like, why is he off seeking asylum? Like, if he was really a whistleblower, he'd come and face some music. You hear this all the time, and it drives me absolutely nuts, because the Espionage Act does not have any public interest defense. The motive is completely irrelevant. The question under the act is, did you willfully communicate what we call national defense information? Was there a willful communication? That's a legal question. And if that gets shown, like, you're done. The rest is begging mercy at sentencing. And the cases that we've seen show that the prosecutions don't seek mercy. They try to make examples out of people. So whenever you hear, well, like maybe Assange can come and get this fair trial, the DOJ's position that's been upheld, and it happened just recently in the Daniel Hale case as well, is that evidence of the public interest served, whether or not there's war crimes, misconduct exposed, is legally irrelevant, and much of the time is inadmissible. So it wouldn't even go before a jury. It's irrelevant. Also, the issue of selective enforcement, which you've likely picked up. Government officials are leaking all the time. Open up the New York Times today, there's probably some classified information, or at least something that could be called national defense information floating around. It happens all the time. The prosecutions in Espionage Act cases lead to harsh and inhuman treatment. So we see that in the isolation that folks have when they're in custody. Right now, Daniel Hale, who's a drone whistleblower, is in what's called a communications management unit, which is a horrible euphemism for basically complete isolation, both inside and outside, even from lawyers. Prosecutions are usually brought in the Eastern District of Virginia. So for non-lawyers, there's different federal jurisdictions that cases can be brought in. And there's a little bit of basically home turf advantage happening in the Eastern District of Virginia. It's the largest concentration of national security agencies there. So any jury pool is going to have someone who's, relative, friend, spouse is working in those three-letter agencies. Also, the judges are super pro-secrecy, sympathetic to U.S. government claims. So EDVA is not, it's not a great place to be there. There's not great rulings. Daniel Hale, who I mentioned, who's currently in a communications management unit. It's a very, very sad case. I encourage you to follow that too. And a lot of the recent decisions in that case, I think, inform the type of trial that Julian Assange would get if he were extradited there. So I'm going to wrap up pretty soon because I do want to hear what folks have to ask or say, but the implications of Assange prosecution would be turning investigative journalism in effect into a felony, because the type of conduct that is alleged in the Assange indictment is indistinguishable legally from what national security journalists are doing every day. So the things alleged in that indictment are obtaining information from a source disclosing information to a journalist publishing national defense information. This is all what Assange is being accused of. I want to very briefly turn to the Computer Fraud and Abuse Act too, because a lot of folks say, well, maybe I could get behind the First Amendment issues of the press freedom violations, but he's also a hacker. There's this computer fraud and abuse count, and what's up with that? Journalists don't do that. But what we're seeing actually, and I have to give it to prosecutors. It's a clever ploy, and there's a lot of thought put into this stuff. But there's been a push actually since the 80s to rile up a computer crimes and hacker threat. And this is through a law called the Computer Fraud and Abuse Act, which is an atrocious law. It actually led, if folks know the case of Aaron Swartz, who is such a gifted activist and computer programmer, but he was a young activist, one of the co-founders of Reddit actually, and worked extensively with digital privacy and security tools. He was basically nailed to a cross by the DOJ to the point where he committed suicide. They were seeking to put him away for over 30 years for trying to make academic materials freely available to the public. And even MIT and JSTOR, which were involved in that case, didn't want to press charges, but the DOJ pushed forward anyway. The law that they used was this Computer Fraud and Abuse Act, which is insanely vaguely worded. It's overbroad, and there's a lot of legal debates actually to its scope. So you might be wondering, well, why is folks recognize the screen grab? It's from the 1980s blockbuster War Games starring Matthew Broderick. And you might be thinking, Carrie, why do you have this War Game still on the screen? It's because literally this movie is the reason we have this horrible law. I wish I was making that up. I really wish I was making that up. But Ronald Reagan was at Camp David when War Games came out, watched the movie. Reagan, who's a former actor himself, he got so freaked out watching this movie, which depicts a teenage high school student who unwittingly hacks into a Pentagon computer and sparks a nuclear war. Absolutely crazy idea, but he goes to his Joint Chiefs of Staff and says, "Hey, is this something that could actually happen? Maybe we should do something about it or pass some law." And literally, in the ensuing months and years, the Computer Fraud and Abuse Act was passed, and it wasn't just it wasn't just Reagan bringing that up. When I dug through the House committee reports actually on the Computer Fraud and Abuse Act, they mention War Games. I really wish I was making that up, but it goes to show the incompetence and terrible threads that run through these laws. But the reason that I bring that up is that language from the Espionage Act is actually cloned word for word in the CFAA. And that's one reason why these two laws are tied together, but they're often separated to try to cast folks as hackers. And there are serious attempts right now to reform the CFAA. The last thing I'll note that Laura Portress, who is one of the original publishers of the Snowden documents, wrote a really important article a few years ago. I encourage you to read it. Some New York Times piece where she said, "I am guilty of violating the Espionage Act," and it was in response to the Assange prosecution. And she says, if you look down a little bit, this is not a hypothetical. Right now, the United States government is prosecuting a publisher under the Espionage Act. The case could set a precedent that would put me and countless other journalists in danger. And she talks about how she and journalists at The Guardian and The Washington Post reported on Snowden disclosures. And she tries to say, like, here are the elements of the crimes that Julian Assange is being charged with. What I did is no different. And that's really what is at stake. This law is contentious and controversial in the legal community. It's never been used to prosecute a publisher for obtaining and publishing secrets, and there's no opportunity to mount an effective defense. Its reach is potentially limitless. The Times, the Washington Post, any media organization is not immune. I wish I could leave off on a better note, but I really hope to hear from you all. I'd love to hear from Thomas Drake. I don't want to put you on the spot, but I would absolutely love anything that you wish to share. And again, I want to thank everyone for your interest in these issues and for having me.
Thank you so much. I learned a tremendous amount, especially not being an American, just so much. Well, I feel we are very indebted to you. You had so much to say that actually we have probably half an hour for questions. I did see one hand was up already. Oh, it seems to have gone down again.
Rose,
yeah.
Rose, as chair, if I may, could we take the opportunity to allow Thomas Drake to briefly introduce himself and describe his case in the context of today's program?
Yes, I certainly appreciate the opportunity to do so as part of this presentation. I just want to thank Carrie for having summarized sort of the egregious nature of the Espionage Act and its origins and how it's been applied. It is true. I was on the receiving end of an Espionage Act indictment, and I was facing 35 years in prison. To say that it was the worst period of my life would be an understatement, because I had to prepare myself, as Ellsberg did, and he was facing 115 years. I had to prepare myself for the possibility that I would end up in prison. I think it's also important to note, just to sort of for my sort of feedback in the moment here after Carrie's presentation, is that people really need to appreciate just how far, and as he highlighted a couple of cases, but how far the government is willing to go to punish you severely for daring to speak truth to power. And I think there is and I'll say an inversely proportional relationship, to use that phrase, I've used it in the past, to the degree to which people, whistleblowers like myself, call out government wrongdoing, violations of the Constitution, fraud, waste, and abuse of intelligence cover-ups, is to the degree to which the government will go after you, because those are the kinds of things, when it comes to criticizing the government, when in fact they're in violation of the very Constitution that they're sworn to uphold. And that's literally the oath I took multiple times, was to support and defend the Constitution, which is just a piece of paper. And although it was fraught with its own contradictions from the get-go, the aspirational nature of the Constitution, especially with the First Amendment, which is the cornerstone. Remember, the original Constitution had no amendments. Those are added as the Bill of Rights, and the First Amendment really is the cornerstone. The government has sought, particularly, as Kerry well points out, since World War I, ways in which to infringe or abridge those rights. And, you know, I ended up being the recipient of 793E under Title 18 of the Espionage Act, which was added during the McCarthy era. And in particular, it was Senator McCarran dealing specifically with the Alger Hiss case, adding that paragraph that they ended up going after me with. And it's true, it's extraordinarily broad. My case is yes, it became public. It was national news. There was a number of international press that picked up on it, saying, what the heck is the US government and why is the Obama administration? They wanted to shut down any kind of dissent, any kind of revelations, any type of exposure regarding government violations of the law, particularly government violations. And so how dare anybody, you know, especially an insider, and I was regarded as an insider threat, which is apparently worse than being a spy. And so,
Thomas, can you tell us so briefly your position in the government, what you saw, and why you blew the whistle and how you did it, and then how the government came after you?
Well, that's sort of the specifics of my case. Is I was a very senior executive within the National Security Agency. I was actually hired from the outside. My first day on the job was 9/11. And within just a few days, I realized that because of the failure to provide for the common defense, which is another obligation of the US government, that we were actually violating the law, that we were setting aside, based on something Kerry didn't mention directly, but it was certainly the Pentagon Papers era, when I was a very young teenager, where all kinds of violations of law and spying on Americans, anti-war protesters, both NSA, CIA, the military, FBI, all came out in a number of different hearings. And I was there listening to, a president of the United States resign their office. So obviously it had a huge impact, including Ellsberg, on what it meant to not be above the law. Well, fast forward, here I am in secret finding out that my own government is violating the law, that they're setting aside the Fourth Amendment, the Foreign Intelligence Surveillance Act, and then the particular internal regulations that govern all that. And we just need the data. And so I early on confronted my superiors, went to the Inspector General. I went to both committees of the House. There was committee hearings on this. This is the intelligence committees, both subcommittee, and then they had a joint inquiry. All of that in summary, right? And then the government had started right after 9/11 a super secret surveillance regime in which they were treating the United States, it turned out, increasingly no different than a foreign nation when it came to electronic intelligence, given that National Security Agency's primary responsibility is foreign intelligence. Well, now the U.S. had become foreign. So I was blowing the whistle on all this, right? I blew the whistle on the secret surveillance regime. I blew the whistle on the massive multi-billion-dollar fraud and waste, and then the intelligence failure and cover-up. So when, for the first time, and this was just the tip of the iceberg, the New York Times published, and I was not a source, although the government claimed I was. Eric Lichtblau and James Risen published an article in the New York Times in December of 2005, revealing for the first time the existence of a warrantless surveillance regime. Well, the government went haywire. They were apoplectic. They wanted to burn the source or sources. I got caught up in a multi-million-dollar criminal leak investigation in which I was ultimately the only one that was indicted for having dared speak truth to power with respect to that program. And so what happened after many years of investigating me, and that's a long story in itself, I ended up being summarily indicted by the Justice Department in April of 2010, facing 35 years in prison, 10 felony count, 5 counts under the Espionage Act, 4 for lying to the FBI agents, which were actually false, although they were alleging I made false statements, and then 1 for obstruction of justice. And so, it was a very bleak future that I was facing. And how do you defend yourself? As Kerry pointed out, it's strict liability law. There is no public interest defense. You can make your case, at sentencing and try to reduce it. But the fact is, if you violate the law, that's all the government has to allege. You violated the law. And so it took not just my own, and I ended up being declared indigent because I was paying a lot of money to private attorneys who, obviously wanted to get paid. I ended up became declared indigent. I had public defenders defending me. I also had Justin Radak is my primary attorney representing me on the outside. And then ultimately I knew I had to influence public opinion, and it took a long time. Jane Mayer came around to write an investigative piece. Scott Pelley interviewed me. I got the Ridenour Truth Telling Prize. This is in now spring of 2011, and I ultimately went free. But the kicker was, this is where the government's, I had to, either plead out, go to trial, or admit my guilt. I did not admit any guilt, but as Kerry pointed out, and I call it something different, the Computer Fraud and Abuse Act, under which I ultimately pled out, I call Espionage Act light. It does incorporate a lot of the language from the Espionage Act, but it goes further in terms of any involvement with the computer opens you up to, again, liability in terms of the legal code, and it's criminal. And so I ultimately pled out to exceeding, again, it's a plea agreement. They dropped the 10 felony counts. I plead out to a misdemeanor and go free, 240 hours of community service and 1 year probation. And here's the irony. As part of that, the judge didn't know it, but he referred me to there's actually an army post near Frederick, Maryland, and I ended up speaking or being put in front of the community services director. It turned out one of the historians, there was a historian who was a civil engineer. He was interviewing veterans for the Veterans History Project and said, "Hey, as part of your 240 hours of community service, why don't you interview veterans?" And ironically enough, I interviewed Ellsberg, an extraordinary set of interviews. Go out to the Veterans History Project in the Library of Congress, 6+ hours of some of the most astonishing insights Ellsberg provided in terms of his life and everything that he did and standing up for freedom and our civil rights and liberties. And so I was free. I interviewed about 3.5 dozen veterans from World War II to the present day, including Ellsberg and others, including veterans and those associated with Iraq and Afghanistan. And here I am, I'm free, but I certainly paid an extraordinarily high price for having dared stand up to defend the Constitution against my own government.
We applaud you, Thomas Drake. Thank you for all of that and your strength and your courage, and that you're able to come out the other side, doing good work, spreading this kind of message. We're immensely grateful to you, Tom.
Thank you. I am in the process of writing a book. So it's taken many years. It's gone through lots of stops and starts. I don't know when it'll be published. Unfortunately, I will have to go through the pre-publication review process because of things I signed, even though I don't want to, and even though nothing is going to be classified in the book, it's going to go through that process. Other fellow whistleblowers have gone through the same thing. There's always the risk that it'll be held up, things will be redacted, but it's important for history because a lot of people don't realize, and I'll share this, just sort of wrap what Carrie presented and also link to Assange. People don't realize my case was the signature Espionage Act case. I was only the fourth non-spy in American history, although there's a couple other weird cases that Carrie's familiar with, who had been charged under the Espionage Act. Fourth, right? There'd been Ellsberg as the first. There was a couple others that ended up, interestingly, didn't go anywhere. One of them Clinton pardoned, and then there was me. And I'm the signature case. I can't begin to tell you, and I talk about this in the book, how far the government went, throwing everything they could, secret. They wanted to do. I had a judge who knew that the odds were great, but I had rights as a defendant. Secret witness testimony, substitution of words, eliminating any evidence. Although the judge overruled that, where the government actually submitted motions. I could not use whistleblowing as a defense. I couldn't use the First Amendment as a defense or overclassification as a defense. And then they wanted to bring the reporter in as an eyewitness, the only eyewitness to the crimes I committed against the government. Sound familiar? A reporter, because I'd given information that was non-classified to a reporter. So it set the frame, it set the tone for all subsequent indictments under the Espionage Act. And as Ellsberg well knew, right, Nixon came really close, and then the government again came close even in my own case, right? And again, there's more details that I'm leaving for the book in terms of sort of the background and what was behind it all. Here we have a non-US citizen that they want to extradite so they can actually use the rights that you have once you're in the United States, even if you're a non-US citizen, and then throw the book at him because he violated the First Amendment. Really, that's why this case is so crucial. It's why we do not want to have Assange being extradited, because if they establish the basis, let's just say he is extradited, and let's say they are able to successfully prosecute him under the Espionage Act and the Computer Fraud and Abuse Act, then that opens up a huge and massive can of worms for any other journalist, reporter, or publisher to be held liable for having been on the receiving end of information the government wishes to censor. And that comes all the way back to the original purpose for the Espionage Act.
Thank you, Thomas. I've said it before, you and Carrie are now card-carrying members of our group, the ICUJP. And when you publish your book, you have an open invitation to return to this group, and we will welcome you for that.
Thank
Absolutely.
you. I definitely look forward to that. I just can't give you a date.
Yeah. Okay. Thank you so much. I'm learning so much this morning. We have two hands up. John, I think you put your hand up first.
Thank you, Rose. First, I really want to just thank Thomas Drake for his courage and patriotism. You're a hero to many of us. If I'm not being greedy, I have two questions for Carrie. The first is that in Stefania Mauriti's book about WikiLeaks, you're quoted as saying that Trump was on a path to initiate more Espionage Act prosecutions in 4 years than Obama did in 8. Obama did 8 espionage prosecutions. How many did Trump do? My second question is, do you have any opinion as to whether the emails that WikiLeaks published from the Democratic National Committee, if they were hacked from without, as Adam Schiff claims, or leaked from within, as Raymond McGovern has said?
So I don't have, thanks for that. I don't have a meaningful viewpoint on the second one, or I haven't thought about it too much recently. On the first, about the number of prosecutions, I was just jotting some notes because it's sometimes the cases get a bit muddled, but I think we're looking at either the same or maybe a couple down. So there are 3 cases that under Trump that implicated The Intercept that we talk about. And there's actually a big controversy around The Intercept and their source protection protocols. Probably the most well known of those is Reality Winner, who's now out of prison. And there's also the Josh Schulte case. He was charged under the Espionage Act. Daniel Hale, who I mentioned, Henry Calfrisi, and I believe depending on where you place Julian Assange, I try to kind of separate him from the U.S. government insider cases. But so the Trump administration came really close in just 4 years, and I think that was consistent with the position of that administration, also Sessions too, because they really made it a loud and clear policy point that they wanted to stamp out what they viewed as leaks. And also what's I think really shameful, I'm so glad that Tom went into the personal cost. I think we have a tendency to view failed prosecutions as like a victory, like, oh my gosh, like this prosecution fell apart, like this is this like win for First Amendment liberties, when it literally like just destroyed someone's life. Like these cases, like they involve national defense and classified information. So, oh, guess what? Your lawyer has to like go down to Alexandria, Virginia and do all their like word processing on some antiquated computer from the 90s. Like folks get bankrupted on these cases. Like they're not cheap. They're crazy stressful. You get isolated. Like, you know, folks, your former colleagues don't even want to be in the same room because there's political radioactivity. So these cases aren't, they aren't victories by any chance. And I brought up Reality Winner because it was really telling the prosecutors, and you look back at the DOJ press release about her case and sentencing, they were bragging. Like she had gotten the longest civilian sentence. So Chelsea Manning was a court martial, was a military court, but Winner was a civilian sentence, and they were bragging about it, saying, "Oh, look what we did," and it really shows that just as they did in Tom's case, which is such a seminal case, actually, Edward Snowden credits Tom with inspiring. His whistleblowing, but you look at what they do in these cases, and they're really trying to nail people to crosses.
Thank you. I'm going to go to Vinny next, and then after that, I'm going to have to bundle questioners. So if you're not Vinny and you have a question, think about kind of just asking them kind of together. So Vinny, you next.
I will be as incredibly brief as I can. I had the opportunity to interview John Kiriakou, and he mentioned to me that the Eastern District Court of Virginia has a 98.2% conviction rate, so much for the presumption of innocence. And he said the reason that they had such success, and I believe Thomas Drake's situation bears this out, is they use something called pump and dump. And that is they throw everything at you. And what Kerry just alluded to, the cost. So I'd like to hear a bit from both of you about the concept of pump and dump. And the second one is the hypocritical selective prosecution that Daniel Ellsberg and John Young have both pointed out that they have done the same thing. And quite frankly, all 5 of the newspapers that publish this are guilty of the same crime, but only Julian Assange is being prosecuted on this. And so I'd like you to address that as well. Thank you. Oh, by the way, thank you to Thomas and thank you to Kerry. This was epic. Thomas, thank you for your courage.
If Tom's still there, I'd love to hear on the pump and dump.
Yeah, just to quickly answer that, there is a trick or a technique or a strategy that the government used that I was certainly on the receiving end of with my defense attorneys, where they're required to provide any discovery information, even if it's exculpatory, meaning not just inculpatory based on charging documents and supporting documents and information, but also anything that would also be favorable in your case. And so what they do is they kind of wait until the last minute. And I still remember, and this was at taxpayer expense, $400,000. They carved out 2 secure rooms within the courthouse in downtown Baltimore, in which, because again, they're alleging all this tippy top secret disclosures to a reporter and retention of same. And where that was the only place where my defense attorneys could go, and those cleared to actually see anything. And I remember it was like the day before, we're only talking a couple days before one of the major hearings, they dumped literally boxes of documents in the laps of my defense attorneys. And I remember they were feverishly going through those with me, trying to see what the government was actually alleging. And in my own case, as much as I was framed, he finally said, "Where's the beef?" They actually did not believe me. They thought that the only reason the government would bring such an egregious charge of espionage is they must have had a smoking gun, and that's what they were waiting for. So all these months go by. We're on literally the eve or two prior to a major hearing. And boom, they dump all this on top of my defense attorneys. And it's designed, and Carrie, you may have a little bit more insight into this with respect to the other cases. It is designed to sort of swamp the defense, meaning they're not going to have the chance of having to wade through all of this in order to mount a defense.
I experienced it actually in the extradition proceeding for Julian. I know that was a UK legal proceeding, but the same similar tactic. So I mentioned I testified in those proceedings, and it was on questions surrounding the Espionage Act and if it had been well-established law in the US and whether it constituted a political offense. But I remember for my testimony, there were materials that the prosecution were supposed to provide to me as a witness as kind of the basis for their cross-examination. So there's kind of a supporting materials packet. And I think I got it like the middle of night or something before I was supposed to testify. It is really wild. And I mean, I think it's been some time now. I'd have to look back, but I think it must have been a few hundred pages. I mean, luckily, a lot of it was, because I'd been working on a book on the stuff, I knew what a lot of these documents were. But honestly, like if I hadn't been, I would have just been completely drowned. So yeah, I'm not surprised by any of it.
Thank you. Carol Francis, the birthday girl, and Steve, if you can both put your questions out there. We're now at 15:15, so we've still got 10 minutes.
Okay.
5 to 10.
Hope to make this quick. I want to know to what extent people who are now coming out defending Julian are talking about the extra nationality of it. I mean, the fact that he's being charged with breaking the law of another country, that he has no obligation can anybody now be charged with breaking the law in another country? It's like if an American journalists were living and working in England and they wrote on Saudi Arabia, would England be holding them and debating whether they should turn him over to Saudi Arabia because he broke a law that's on the books of Saudi Arabia. And is this something, I mean, it's one of the most egregious things about Assange's case, but is this something that you're hearing people talk about now?
Yeah, I tried to make that point earlier about what would happen if someone exposed abuses surrounding Ukraine and the country sought their extradition. This is, I mean, it's really sad because I mentioned I do a lot of work surrounding international law, which is there are numerous international treaties and regional mechanisms, but a lot of international law is custom driven. So it's really based on international norms and behaviors and precedents set by countries, because you don't have you do have different courts with jurisdictions, but they're only as powerful as countries allow them to be, as we see with the International Criminal Court in the United States, which has refused to accede to jurisdiction for anything that it's done in these wars. But what's really sad about the Trump administration is the U.S. is detached from a lot of these international engagements and commitments to international human rights. And I think what we'll see in this case too is exactly what you pointed out, Carol Francis, where you have an increase in basically where countries are empowered and now legitimized to seek extraditions, and not just from the United States and other countries, but say you have say a journalist in Bolivia or so has is going to be extradited somewhere. Like, these impacts are going to be felt around the world, and not just with the US and UK, but with many other countries. And that's one of the biggest harms, I think, is the international precedent, not just the precedent for US law, but also international precedent.
Thank you. Steve?
I wanted to ask Peter Becker if I saw your hand go up, and defer to you if you have a pending question, or did I misunderstand? No?
No, not.
You're okay? Carrie, within such limited time, you mentioned the Computer Fraud and Abuse Act. Can you briefly describe why that is a trumped up charge, if I can use that expression as well?
Yeah, sure. So the Computer Fraud and Abuse Act, like the Espionage Act, has many different provisions, some related to things like financial crimes or banking, etc. But as Tom pointed out, there are provisions that are cloned verbatim from the Espionage Act that basically punish the same conduct of the Espionage Act. So that's the willful communication of national defense, the national defense information languages in the CFAA, except plus involving a computer. Basically, the offense that's implicated is whether there's authorized access to a computer. And there's actually a big legal debate. There's a Supreme Court case actually just last year on this point. What does it mean to have authorized access? This is a huge debate. And actually, one of the leading CFAA scholars, Oren Kerr, he's a former prosecutor. He's not sympathetic to Assange, but when the indictment came out, he actually tweeted out that the government's theory was like really pushing the boundaries of this interpretation of what authorized access means. And I told that in the cross-examination. I mentioned that to the prosecutors. I mentioned Oren Kerr, and they didn't want to talk about him because he's someone who's really respected, and I when it comes to those issues. So really what's alleged is that basically it boils, and I think it gets kind of technical, but basically that Assange attempted to help Manning break a password, but it's more nuanced than that even, because Manning had, as I understand, Manning had access to the underlying materials. It was a question of basically source and identity protection. So from a alleged attempt at an attempt, you've got to, well, this is a hacker. when there's nothing substantive that actually happened.
Thank you. A wonderful morning. Wonderful is the wrong word for it, but thought-provoking, et cetera, et cetera. Said you've educated me a lot. We now, are there any information, any notices about any other organizations that we are affiliated with that anybody needs to share before we come to our closing circle?
I do.
Yep.
So next week, we are going to be hosting Taher Herzallah of American Muslims for Palestine. This is somebody that Carol Francis brought to our attention. So those of you who are on the call, if you can make it next week, that would be great.
Thank you. Thank you. And just before we come to our closing circle, I do, because we have people here that we don't normally have, I do want to reiterate the fact that we do need money. Zoom is not cheap. Well, it's fairly cheap, not super cheap. We do have a small paid staff who is extremely efficient, does a wonderful job, but also has to live and eat. So I just wanted to kind of make that little plea again. It's very easy to donate just on our website. Thank you so much. And hopefully see you next week. And as Rick said, it's a pretty important one next week. So maybe some of our newcomers will check in as well. Thank you and have a wonderful week.